Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, doing the live stream like we try to do each and every Thursday night. We took a week off last week for Halloween. Man, that seems like a long time ago. We made it through Halloween. We made it through the presidential election that just happened, and but we're back here to talk about all things debt related. Again, my name is John Skiba. I'm an attorney in the state of Arizona. I help people mostly with consumer debt type issues, whether you're looking for bankruptcy, whether you're dealing with a wage garnishment, defending a debt collection lawsuit. And so I practice here in Arizona. If you are in the state of Arizona, my information is scrolling along the screen here. I forgot to do this. Today's been a busy day, so I'm a little bit less prepared than normal as far as having all my things up. But I'll put a link in the chat section there. If you are in Arizona and you want to set up a consultation, you can just set it up and you'll talk to me. And it is just me. People think that I do this and then I have a whole team of attorneys. I wish I did, but it's just me. You'll talk to me and we can see if we can help you out with the situation you're dealing with. That kind of goes right along to my weekly disclaimer that while I am a licensed attorney in Arizona, not licensed anywhere else. So I can't give any legal advice. I can't even do consultations, one-on-one if you're not from Arizona. And so if you're from out of state, hopefully this helps you out here. Take it for what it is. It's not legal advice. It's just some guy talking on YouTube. So let me throw in the link there if you want to set up a schedule. And I also want to thank real quick the folks over at Solo Suit who sponsor this weekly live stream. You'll see in the chat section there in both Facebook and on YouTube a link to some of the tools that they have that can help you with debt settlement, debt collection, lawsuits, drafting an answer, all those kind of things. If you're not in a position to hire an attorney, financially, if it's not in your budget, or it's something you feel like, hey, you just need to handle on your own, they have some great tools that can help out with that. And actually, I'm going to have one of the co-founders, George Simons, he's going to be on the live stream next Thursday. So make sure you check in for that one. It's going to be really cool. We're going to talk about Solo Suit a bit, kind of what they do, their place in the market. I think it's kind of an interesting, because it's not a law firm or anything like that, but they are helping people with these junk debt buyer lawsuits, which I do a lot of. So that's next Thursday, 5:15 Arizona time. I say Arizona time because we're one of the few states that the clocks don't change. And so because of that, I don't know, half the time we're on California time, the other half we're on like Colorado time. Who knows? It's Arizona time, 5:15 Arizona time. So check that out. Before we jumped into the questions, and by the way, if you're new to the live stream, that's typically if you have a question you want us to talk about here, put it in the chat section on YouTube, put a comment on Facebook. I'll put it up on the screen and we'll talk. This week we made it through another presidential election cycle. And something I get asked quite frequently, when it comes to consumer debt, bankruptcy, lawsuits, all that, do I see big differences between presidential administrations? I just entered my 22nd year of handling these types of cases. And so there's been, numerous administrations that things have gone through. The answer is really not really. I don't see a whole lot of difference. Part of it is when it comes to like debt collection lawsuits, particularly with junk debt buyers, the wheels started moving on that years ago. Most of these accounts are 4 or 5 years old. They may have old default judgments. Not only that, I just don't see, with the administrations day to day. Sometimes with student loans, the last 4 years, we've seen a little bit of where the U.S. Attorney's Office, they weren't contesting dischargeability of student loans in bankruptcy as aggressively as they had in the past. But we even saw that towards the end of the last Trump administration. So I think student loans is one of those kind of hot button issues that eventually I think that it will go back to how it was, maybe even when the law changed back in 2005, where you could often get rid of student loan debt if you could show hardship. So I don't see a big, I know that's probably not a very hot take, but I don't see a lot of change from year to year, administration to administration on how things are done. Now, back in 2005, like I was saying, the bankruptcy code was completely rehauled. That's something that was years and years in the making, several administrations. And so things move very slowly in that area. But I don't see a whole lot of difference in between administration to administration. So, all right, well, let's jump into the questions. There's quite a few already. I saw Rob was here nice and early. Rob said, good evening. Update on my ongoing case. During the oral hearing on October 18th, where the plaintiff showed up but did nothing, leading to a new trial date of November 15th. On November 4th, they filed a motion for summary judgment, and the judge accepted the motion and signed an entry giving me 28 days to respond. The last assignment issued says private review decision on the bench. It's funny because they stated no disputed material facts, yet there are still disputes. So this is one of those things, like I said, it's one of those, if there's a trial date, at least in most jurisdictions, there should be a deadline for filing what we call dispositive motions that'll dispose of the entire case. If you have a trial date, man, you were saying the trial date was on the November 15th. There's not even sufficient time for you to be able to respond to it. The court gives you 28 days to respond to it. Sometimes I think this is courts just thinking, hey, I don't want to do a trial. Let's just get rid of this thing through a summary judgment motion. But that may give you a basis for appeal if the court rules against you. So that's something to take a look at. All right. Joe says, I'm in desperate need of a new car since my 2001 truck is on its last legs or tires. I was thinking of cashing my 403B, putting it down as a down payment, but still owe on it. If I file for a Chapter 7 bankruptcy, will I be penalized for it? I just recently retired. No. That's not going to cause here's the catch. Well, one, I should say this. A couple things to consider if you're thinking of filing a Chapter 7 bankruptcy. Retirement accounts like a 403B, a 401k, IRA, those are generally exempt in most jurisdictions. They can't be touched by a bankruptcy trustee. Your creditors can't come after them. So they're basically protected. So if you left the funds in there, they are protected. The other thing to consider is if you buy a vehicle right prior to the filing of bankruptcy, if you're going to finance it, it's important that you, one, consult an attorney with how much you can actually put down on it. So like, for example, in Arizona, you have a $15,000 vehicle exemption. That means you can have up to $15,000 of equity in the vehicle. So if you were to go out and buy a new vehicle, if you were to pull 25 grand out of a 401k, put that down on a $50,000 vehicle in Arizona, that would cause problems because you put 25 grand down, you probably have more than the $15,000 of equity that the law allows. And so that's something I see in the chat section. You're in Texas. I would, I would definitely talk to an attorney in Texas and find out exactly how the vehicle exemption works there. Another option you might want to think about is the 403B is protected. Maybe you file your bankruptcy case and then after bankruptcy, take a distribution from your 401(3) to get the vehicle at that point. Because Chapter 7 is concerned with the day the bankruptcy case is filed with the court backwards. In general, they don't care about things that go on afterwards. They care, but it's not, they're more concerned with transactions, money moving around, income, all that from the date of filing backwards than they are with certain transactions going forward. So, Joe, and you asked what's the best way to find a lawyer. There's a group called NACBA. It's National Association of Consumer Bankruptcy Attorneys. I'm going to put let me see here. I can put a thing here in the notes. Let's see. I thought they had like a lawyer finder. I'm looking at their website right now. Yeah. Well, so I will. I found it. Okay. I know this is not very good video, but let me do this. Let me put this in here. So if you're not in the state of Arizona and you're looking for a bankruptcy attorney, NACBA is a group, like I said, National Association of Consumer Bankruptcy Attorneys. If you're a member of NACBA, you do mostly, if not exclusively, consumer bankruptcies. You're not doing a lot of business cases or anything like that. And you don't represent creditors. And so people who are members of NACBA, you have to pay to be part of this organization. They have big conferences and, continuing education things. You don't just dabble in bankruptcy if you're a member of NACBA. This is something you do as a profession, and you're going to get someone who is a very beneficial to you. So check that out. I put the lawyer finder in there. You can put your zip code in and find someone who's a member there who should be able to help you out. All right, let's see here. Carmel saying he has a case from LVNB in New Hampshire. Ugh, I hate them. They're not my favorite either. They're a pain. All right, Julie says, State Bar Association. That's a good one too. And this kind of goes on to a question that actually I saw on the YouTube channel. I'll put this up. It says, can I file Chapter 7 without an attorney? Can you do bankruptcy without an attorney? I always smile a little bit when I get this question because you're asking a lawyer. This is how I make a living by filing these cases. The answer, of course, is yes. I mean, you can file your own bankruptcy case. The question then is, should you be filing your own? A lot of it depends. People do file their own Chapter 7 bankruptcies all the time. A lot of it depends really on how many kind of moving parts you have in your case. The bankruptcy process, in times past, there was a kind of a feeling that it was kind of filling out forms. It's not. There are forms, about 100 pages of them, but there are a lot of moving parts, listing assets, claiming proper exemptions to make sure you protect your property, listing all your creditors, making sure that's listed correctly, making sure all the parties are served properly. All those kind of things can play into it. And if you don't do it right, it can cause you some big problems down the road, and it will cost you way more than an attorney will cost you early on. Bankruptcy, as far as legal fees go, I don't care what state you're in, it's relatively minor compared to what most attorney's fees are. The way I frame it a lot of times is, let's say you had $50,000 of debt, but you found out it was going to cost you $2,000 to $3,000 to pay for a bankruptcy attorney. If I would have come to you and said, hey, I know you owe 50 grand. Will you, if you pay $3,000, it'll all go away. You would jump at that chance. So I get it. Paying attorney's fees is never a fun thing, but that's maybe a way to think about it. But kind of along to the comment there are, in most states, you can contact the state bar. There is a pro bono thing where they'll handle them for free. If you're in the state of Arizona, down at the bankruptcy court in Phoenix, they actually have a self-help center. They have attorneys who are staffed there that can help people who are representing themselves. They cannot represent you. They can't give you specific legal advice. And so that's something that you would have to, but they can provide some information. And I think a lot of bankruptcy courts will have that. So you may want to give the bankruptcy court a call and see what they have. All right. Dark Emperor says, I had an LLC small business, which has been liquidated with zero assets, and I'm in the midst of a personal Chapter 7. What happens if the LLC creditors sue the business now, such as small claims? If the business has been liquidated, so a couple ways to look at it. If the LLC is still an active entity, and what I mean by that, I understand that it's no longer doing business. It's not, you're not conducting business. There's no assets. You said they're all liquidated. But if the LLC is still on the books, if it's still active, like with the Corporation Commission in your state, it still offers some protection. They can still sue the entity, but if they get a judgment against it, there's not a whole lot they can do. Now, if you have wound it down, if you have closed that entity and it's something where the LLC no longer exists with the Corporation Commission, there is some authority that'll say the debts of the corporation have now become yours personally. So when I have clients like this that are business owners, they've wound down the business and they have a Chapter 7, and there's some creditors out there, even if we think they're just business creditors, I always include them in the personal Chapter 7 bankruptcy filing. That way it eliminates any personal exposure you have. Now, if it is just an LLC and they're suing the LLC, they can knock themselves out. There's nothing to collect. If the assets have all been liquidated, there's not really a whole lot that needs to go on there. So, all right, let's see here. G Trading 8 says, I need to file as soon as possible, but I was advised to wait after getting my tax refund, and I can pay with the fees and any late on my mortgage. Yes. So the way that tax refunds, it always, at least in times past, like March, April were always the big time of year when people file bankruptcy, because people would use their tax refund to pay for the legal fees. That's changed a bit in a lot of states. It used to be that they required you to pay all of the legal fees up front before your bankruptcy case could be filed, which never made sense to me. This is a time, and most people who are going through bankruptcy, it's like their most financially stressed time. and the courts were forcing them to say, hey, we're going to force you to pay this big lump sum of attorney's fees. It just didn't make sense. In most jurisdictions now, you can pay the attorney's fees over time in monthly payments. I know I do that in my office with almost all of our Chapter 7 cases. We can file the case just for the filing fee and then create a payment plan for the rest of the attorney's fees. But so what you're stating here, there's a couple of reasons as far as the timing of the bankruptcy. It's important to understand in some states like Arizona does not have an exemption for tax refunds. We also don't have an exemption, like it was called a wild card exemption, that could be applied to a tax refund. So in Arizona, for example, let's say that you file your bankruptcy in January of 2025, and then you file your taxes in, let's say, March of 2025, and you become entitled to a $3,000 tax refund. If you're in the state of Arizona, the bankruptcy trustee will say, thank you for that $3,000 tax refund, and they distribute it pro rata amongst all of your creditors. You lose it. However, again, and this is an Arizona thing, if you file your taxes at the end of January or beginning of February, you get the $3,000 refund, and you use that to hire an attorney, which is always good. It's always good to pay your attorney's fees. Or let's say you buy groceries or the refrigerator's broken and you need to replace it. Whatever you do, you spend it and you use it for just general living expenses and then file your bankruptcy. You don't have to give up any of your tax refund. Now let's stretch it out even further. Let's say that you file your bankruptcy case in November of 2024. When you file your taxes in Arizona next year, and in April of 2025, and you get a tax refund, a portion of your tax refund is going to go to your creditors. And how they calculate that is they look at how many months into the year you were when you filed your bankruptcy case. So you're in Arizona, or you're in November, we're filing the case. It's in the 11th month. And so you're 91% through the year, 91% of your tax refund for the following year is going to go to your creditors. 9% will go to you. So, whereas compared to if you were like in month 6, then because you're halfway through the year, half would go to your creditors, half would go to you. So that's how they do it. In Arizona, there's really no way around it. Other states have exemptions where you can exempt out that tax refund. There's some other little complicating issues sometimes in there, but that's kind of what it looks like. So, all right. Derek says, United Collection Bureau, are they junk debt buyers or legit collection company for the original creditor? They are a collection company, debt collection company. They typically do not buy debt. I better make sure. Yeah, because I've dealt with them before, but they don't buy debt. They're hired guns that these companies will hire. I think they do a lot of medical debt that they'll hire and then pursue that. So, all right. Hey, we got Alex. Alex, it's been a while since we've had you on the channel down in Yuma. Shout out down to our friends in Yuma. Alex says, if you receive a payout from a life insurance policy, will that be included in the bankruptcy estate support from Yuma, Arizona? Now, if you receive a payout from the life insurance policy, depending on which state you're in, there are different exemptions that can be claimed. In Arizona, the payout or the exemption for a life insurance policy is $20,000. I'll double check that number, but the last time I looked at the statute, only $20,000 of it's protected. So if you have this $500,000 term life insurance policy that pays out during your bankruptcy, you may have to turn a big chunk of it over. They just pay off the creditors. So if you have $50,000 in credit card debt, they pay that off, and then you get the rest. But it's not all going to go, to you. You're going to lose some of it. So, all right. There's one more question on the comment section. And we had a question about this early on. Said, how do you respond to a motion for summary judgment that a creditor has filed with the courts? Now, the way that most debt collection cases proceed is they file the lawsuit, they serve you with it, you file your answer. 30 days later, approximately, initial disclosures are exchanged, all their documents. And then often they will file a quick motion for summary judgment. Or like we heard earlier tonight, sometimes they do it right before trial, which in most jurisdictions they shouldn't be allowed to do. So what they can, the motion for summary judgment is, in essence, what they're doing is they're saying, hey, judge, we don't need a trial. just look at all of our documents, look at all of our exhibits, and tell us that we win. And then if we do win, there's no trial. Now, you have to respond to it. If you don't respond to summary judgment, the courts are required to look at it and make a determination whether there's enough evidence to support judgment. At the same time, they have to, if you don't respond, a lot of courts will just rubber stamp that thing and it's done. And responding to the motion for summary judgment is more difficult than responding just like the answer. When you file an answer to the lawsuit, it's more of just, admit, deny, that kind of thing. But if you file a response to motion for summary judgment, you have to come in and provide substantive responses to it. You have to cite to case law and show why there are factual disputes that need to be resolved at trial. The creditors, the attorneys for the debt buyers, they know that most consumers struggle a lot on this. I do have a tutorial on it that shows you how to do it, but it is more difficult. I'll find that link and I'll throw that in there. But that is something that absolutely it's a trickier thing that people deal with, and something you got to be careful of. If you get it, don't ignore it. That may be a time to talk to an attorney. If you're in Arizona, set up a consultation with me. I'm happy to see what we can do. So, all right, I think that's going to be it for today. Why don't again, next Thursday night, I'm going to have George Simons, co-founder of Solo Suit. We're going to talk about all things debt collection, lawsuit related. He has I practice in Arizona. He has perspective from the entire country because they deal with people in all 50 states. So tune in next week. I'll put a link up so you guys can remind yourself of that. And with that, we'll catch you next